Tithing can be a legitimate personal expense in the context of determining an alimony award. Now, whether my recollection is true or not, I remember being taught in law school that tithing and other regular charitable giving cannot be treated as a personal expense deduction in bankruptcy. It appears that is no longer true, if it ever was. I was taught as a divorce lawyer by people who should have known better that tithing or regular charitable giving could not be considered a personal expense when analyzing need and ability to pay in the context of the alimony award. Now, I don't know if that was ever true, but I know it's not true now. In the Utah Court of Appeals decision in the case of Knowles versus Knowles, which was a 2002 case at 509 P. 3rd 265, the trial court refused to include tithing expenditures as part of the alimony calculation because it was, in the trial court's opinion, quote, not a necessary living expense, close quote. The Utah Court of Appeals reversed that decision, explaining that the trial court, quote, ignored the requirement that trial courts assess the expense based on how the parties chose to spend and allocate their money while married, close quote. The Court of Appeals decision in the case of Mintz versus Mintz, which is 2023 Utah Appeals Court 17 at paragraph 24, opined, quote, the marital standard of living analysis is not merely a question about what the parties spent their money on or whether they spent it at all. Rather, in terms of alimony, the marital standard of living analysis is about whether the parties' proposed points of calculation are consistent with the parties' manner of living and financial decisions, i.e., their historical allocation of their resources. Something may contribute to the marital standard of living even though it may not result in a direct benefit or detriment to the marital estate's net worth, close quote. Tithing is a legitimate expense.